Lobbies and Gentlegrams, as I was recording this video, some very important information came out from the desk of UMG and the CEO, Lucien Grange, where he establishes under oath that they purchased and own the bulk of Drake's recording catalog. Some absolutely insane stuff, so I'm going to take you guys through in this video every update about the lawsuit, but if you want the most recent update, you'll find that at the end at about the 45-minute mark. Stay tuned, like and subscribe, all that jazz. Love you guys. Enjoy the video. Lobbies and Gentlegrams, in today's episode of Lobby in Gentleland, we've had a long week of whimpering Wonder Women whining and signing suits of the law to latch Kendrick's kids in court cases over a battle that left Lobby in awe. His rich baby daddy Lucien did not protect him, so now he plans petitions to perplex him. And the man who studies rap battles for a profession is requesting info on Kendrick's kids for his discovery dissection. But what's interesting is how we now have the transcription of the court hearing where the judge gave Drake permission to tear through UMG's files to find fact or fiction. But the judge wasn't kidding. He clowned the Canadian Katy Perry in court. So let's unpack everything the judge said to Lobby's lawyers over the sport of rap battles, because it seems like even though Lobby studies them for a living, the judge had a better understanding of what diss songs should be giving. Is it defamation or lyrical annihilation? Let's find out. But first, smash that like and subscribe button. Come on, don't make me beg you for the clout. Now, Lobbies and Gentlegrams, before we review the transcript of this court hearing between the judge, UMG's lawyers, and Drake's lawyers, I actually want to bring up something very funny. So, of course, this entire lawsuit is about the fact that Drake feels like his name was defamed for Kendrick, alluding to the fact that he's a PDF on Not Like Us, right? The lyrics in the song say, Drake, I hear you like I'm young. The cover art with the S-Offender pins on Drake's house. The music video where Kendrick has a bunch of shipping containers and he's playing hopscotch. It's all just one big defamation debacle to destroy the drizzler for being a diddler. But what if I told you that the rap battle studier, the sexy red stunt double, did the same thing in a rap battle of his own?
I study rap battles for a living.
Way back in March of 2009, about a couple weeks after he released the mixtape that would make him famous, So Far Gone, Drake had released a diss track called Good Riddance, where he featured a bunch of different rappers to basically end the career of another artist by the name of Aristo. Yes, Drake was allegedly really ending careers before even starting his own. And the description of this song on Rap Genius reads, "This was probably one of the last Drake diss tracks after he stated that he didn't have time to respond to any more beef. Everyone featured on this diss track has been affected by the artist Aristo in some way. Aristo was never really famous, neither was Drake at the time that this track came out. Drake single-handedly retired Aristo, no doubt. The last line Drake raps pretty much sums up the whole reason for this track. Good riddance, Aristo, I just retired you." And in this song, La Brianna tries to pull an Eminem on 8 Mile where he disses everything about himself, rapping, "F the money and the cars that I drive to the set," because again, at this point, he was still an actor on Degrassi driving to a set. "F the women that's lying to all the guys they met," and "F the features on my songs and the deals on the table," because again, he wasn't signed at this point. Or basically, it's F everything that you strive to get.
I study rap battles for a living.
And he also, I don't know if this is a diss to Joe Budden, but he definitely references the fact that early on in Drake's career, he was copying Joe Budden's flow. Because Drake raps, "If I copy Budden's flow, you're mimicking his career." Is he saying that Aristo was as unsuccessful of a rapper as Joe Budden was? The funniest to me is that even back then, like, Lobby was known for stealing flows. Drake also admits to taking L's in rap battles in the past.
I study rap battles for a living.
He raps, "Yes, I took an L on my own, and they didn't damage me. You try to cover up your lies like a canopy." And this is where it gets crazy, because then Drake raps, "You're trying to cover up your lies like a canopy and trying to pull 17-year-olds down in Bramley. I know about it. And we don't got it out for you, we're just saying that nobody could vouch for you." And before we touch on that bar, I also find this funny because the people he's dissing in this verse, he also claims that they would snitch, rapping, "You probably snitching in court, then accept the plea." And he references young girls one more time in this verse, rapping, "They say Drake killed it like young girls at a private school." Because I guess in private schools, the women would wear kilts as a uniform. So in this track, Drake is owning up to the fact that he copied Joe Budden's flow, that he's taken L's in the past. He's calling people out for snitching and taking pleas in court. and he's referencing the fact that his battle opponent is allegedly a PDF.
Yo, shout out to all the 12-year-olds in the building. What's up? It's mad 12-year-olds in this tonight. Crazy 12-year-old.
Doesn't this sound familiar? Drake is rapping at his opponent, saying that he would snitch in court and that he's a PDF. 15 years later, Drake is in another rap battle, gets called a PDF, and snitches in court.
I study rap battles for a living.
You can't make this stuff up. You really can't. And with that, let's break down the first court hearing that La Brianna had for this case against UMG over the song Not Like Us.
I study rap battles for a living.
Just to catch you guys up to speed, this court hearing we're going to review took place on June 30th, 2025. So it was about a month and a half ago, but it plays a very important role in what we're going to see in the future of this case. More important than the other document we reviewed, which was basically just Drake's legal team requesting a bunch of information from UMG. To simplify how the sequence of events have gone so far, essentially Drake files the lawsuit, UMG goes to the judge and says, "Judge, this is a BS lawsuit, let's throw it out." That's what's called a motion to dismiss, aka a request to just have the whole case deleted. Then we get this first court hearing where both Drake's team and UMG's team plead their case. UMG explains to the judge why the case should be thrown out. Drake's team explains why it shouldn't be thrown out. The judge asks a couple questions to understand the context of the rap battle, why this was defamation, how it could be considered defaming Drake, and whether or not the case should proceed or should they cave into UMG and dismiss it in general. A little spoiler alert for you, the judge did decide to reject UMG's motion to dismiss, aka reject the idea of throwing the case out. They allowed it to proceed, and so that's why you now have this new document being released from Drake's legal team where they're requesting a bunch of insane things like communication that UMG has had about Kendrick or Dave Free or Kendrick's kids, or any information UMG has about allegations relating to Kendrick abusing people, or any communication UMG had with Screwface John. It really got that ridiculous where they're requesting what UMG knows about the rapper slash YouTuber Screwface. But let's review this court hearing that they had on June 30th, because we never fully saw, how Drake's lawyers have been interacting with the judge and what the judge really thinks of this entire situation. And it's really hilarious, to tell you the truth. Like, with the angles the judge is taking here, the questions they're asking Drake's lawyers, it seems like the judge has studied rap battles better than Labrie has.
I study rap battles for a living.
But let's dive into it, Labries and Gentlegrams. So it starts off how any normal court hearing would. Drake's lawyer comes to the stand. "Good morning, Your Honor. I'm Mike Gottlieb, representing the plaintiff Drake." The judge says, "Good afternoon, everyone. We're here today to hear arguments on UMG's request to dismiss the lawsuit that Drake filed. Let me explain how we'll proceed. Since this is UMG's motion to dismiss the case, they'll go first. Then I'll hear from Drake's lawyers. Then UMG can give me a rebuttal. And here are the specific issues I'd like you guys to focus on. Number 1, can I decide right now, at this early stage, whether the statements in Kendrick Lamar's lyrics, the ones that Drake says are defamatory, are facts or opinions? Number 2, if I can decide that now, should I, and to what extent should I, consider the documents UMG submitted with their judicial notice request? And number 3, using New York's Steinhilber factors, are these statements facts or opinion under New York defamation law and the New York State Constitution? Now, what the New York Steinhilber factors are and how they relate to defamation cases is essentially the Steinhilber factors are a New York test to decide if a statement is a fact, and a fact, of course, could be defamatory, or are the statements an opinion, which is usually protected under free speech laws. Courts will look at whether the words are precise, if they can be proven true or false, and whether the context shows that it's an opinion or it implies hidden facts. So what they're trying to see here is, are the lyrics in Not Like Us discernible as opinion or fact? And that will conclude whether the judge thinks that it can pass for real defamation. And on a side note, drop a subscribe again, because I'm sitting here summarizing and simplifying all the language in this complex transcript. I'm gonna make sure every word sounds very, very simple here. Oh, and while you're at it, if you think I drop too much Drake content, first of all, we're always gonna be covering this disgusting lawsuit, but I have a bunch of other documentaries on the channel that, in my opinion, are by far the best videos I've ever put out. So please go check those out as well. I did one on Doechii, The Clips, Tyler the Creator, DJ Khaled. Go show some love. So, with that being said,
I study rap battles for a living.
it's UMG's lawyer's turn to take the stand, and they proceed by saying, I'm going to focus on Drake's defamation claim first, although I do also want to briefly touch on the two other claims made in the lawsuit. Our main point, and it's also tied directly to the court's questions, is that the statements in Kendrick's lyrics are non-actionable opinions, not statements of fact. And what they mean by Kendrick's lyrics being non-actionable opinions is that a non-actionable opinion, it's a personal view or judgment that cannot be proven true or false. It's like saying, I think he's rude. A statement of fact makes a claim that can be proven true or false, like saying he stole $500. They continue, under New York law, whether something is a fact or an opinion is a legal question for the court alone, not something that a jury decides. And because of that, it's especially suitable for a decision now, at the motion to dismiss stage. There are multiple cases where courts have thrown out claims on this exact basis. And frankly, I find it surprising that in Drake's entire 27-page brief, he never once acknowledges that this is a legal question for the court, rather than a factual question for the jury. Basically, what they're trying to say here is that in New York, deciding if a statement is a fact or opinion, that's up to the judge, not the jury. And that means that the judge can make this call early in the case before it even goes to trial, so the case can be dismissed right away if the statement is just an opinion. And of course, Drake's side is arguing that Kendrick's statements in Not Like Us are fact. UMG is arguing their opinion. So UMG is pointing out that it's weird in Drake's case, they didn't emphasize that normally it's the judge who makes these type of calls, not the jury.
I study rap battles for a living.
And the judge says, let me stop you there, because you're right. There are cases where the judge decides and some cases where the jury decides. And the judge points to two different cases. We'll refer to them as Bryan and Davis. In the Davis case, the court leaned heavily on the fact that it was very early on in the defamation case, and they said that the standard at this stage was whether the statements, taken in their normal meaning and context, could be understood as having a defamatory meaning. And if they could, then the motion to dismiss should be denied, aka the case should move forward. But in the case of Bryan, they allowed dismissal of the entire defamation lawsuit because the statement that was made used an objective standard, asking if a reasonable listener would hear the statement as an opinion versus a fact. So UMG's lawyer replies, saying, firstly, this lines up with how the court described it. The question of whether a statement could have a defamatory meaning is different from the question of whether it's an opinion or a fact. On the it could be defamatory question, there are cases suggesting that if there's a dispute, it might go to a jury. Because again, we're dealing with very kind of ambiguous, broad statements here, right? Like, it can't just be as black and white as, is this an opinion or is this fact? There are situations where a reasonable listener could listen to it and say, it could be defamatory. So in those type of cases, the decision on if it's defamatory shouldn't lie with the judge, it should lie with the jury. And this is just important because in the future, as we break down this case as it proceeds, you're going to have to know what is the judge thinking, what is the jury thinking, and what type of precedent does this set with lyrics in a rap battle. So it's two separate questions, right? Question one is this fact versus opinion? Question two is, could this be considered defamatory by a reasonable listener? And that's what Drake's case is relying on. They want to rely on the fact that even if Kendrick was speaking from an opinion basis, not a fact basis, it still could be considered defamatory against Drake. Even if he's saying, I think you're a PDF, it could still be considered, even though it's just his opinion, as defamation. And UMG's lawyer continues because they have to use previous cases as precedent, right? Precedent is just basically like whatever happened in the past can kind of dictate how you make decisions in the future. That's why everyone thinks this legal battle is so dangerous, because if Drake can get away with winning a defamation case about rap lyrics, it sets a new precedent, a new standard for how rap lyrics are judged in court. So UMG says, what's key about the Davis case and why it survived the motion to dismiss is because the court concluded that the speaker's statements suggested he had undisclosed information, aka in that case, it wasn't thrown out right away in the motion to dismiss stage because even though the statements could have been opinion or they could have been fact, the statements that were made suggested that the speaker of those statements had undisclosed, unrevealed information. And Drake's trying to make that same argument here with Kendrick when he raps stuff like, "The rabbit hole is still deep, I can go further, I promise," insinuating that there's more to the PDF claims than what he has said already in Not Like Us. And they continue, when you go through that Davis case, the main driver of the outcome to not shut down their defamation case right away is that there was multiple things that would make a listener think the speaker had inside knowledge that no one else had. For example, the speaker referred to a university investigation when he was explaining his conclusion. He had a position of authority at the university so he could speak with credibility and seriousness. He made statements before the results of the investigation were public. His comments were made for an article in a formal discussion and didn't sound like extreme exaggeration or name-calling like they do in Not Like Us. And all of that led the court to think a reasonable listener could hear those statements as fact and then therefore defamation. But here in this case, we have none of that. We don't have the same context. We don't have any indicators that suggest that the statements in Not Like Us were of fact based on some serious investigation that the speaker, aka Kendrick Lamar, was privy to. And the judge replies saying, "Since you're bringing up context, let me ask, isn't the logical conclusion of your argument that statements made in a rap battle or diss track are always just opinion? Is that really consistent with New York case law?" New York courts have said the setting isn't necessarily the deciding factor, but it seems to me you're saying the setting is the deciding factor here. That if it's a rap diss track, it just can't be taken as fact. UMG lawyers reply, "Your Honor, I'm not saying that the forum, aka the setting in which something is said, is always the deciding factor. I agree with the general idea that it's not automatically decisive. Usually this issue comes up in cases involving something like an opinion column or a letter to the editor. In those situations, the setting would make most people think it's an opinion, but courts say you can't just stop there. It's possible that even in a place where heated rhetoric is expected, the content might still be treated as fact." Basically, in like an article, it's a lot clearer if something is an opinion or fact versus a rap battle. So they continue. Now, could a diss track in a rap battle ever cross the line of being factual? That's an interesting question. My view is that the nature of rap battles makes that very unlikely, maybe even never. But here, we don't need to answer the hypothetical. We can look directly at this case. The lyrics in Not Like Us are clearly over the top, trash talk, extreme insults, what courts would call rhetorical hyperbole. And under both New York's highest court and federal court rulings here in the southern districts, that's strong evidence that these are opinions, not facts. In fact, there are cases much closer to this situation that show when context is this obvious, it is decisive. For example, in the case Hobbs versus Amos, the court threw out a defamation case against Don Amos, who was a shock jock radio host. They threw it out at the motion to dismiss stage, which is where UMG is at right now. They're trying to get the case dismissed, aka a motion to dismiss. The court didn't just look at the specific statement in isolation. It considered Amos's notorious history and the entire nature of shock jock radio. The conclusion was, in that context, people expect outrageous statements, so they're opinions. The court even admitted that if you took the words alone, they might sound factual. But when you remember it's shock jock radio, you see that it's opinion. The same principle applies here. The judge says, let me stop you there. Here, the context is a rap diss battle, and we're at the motion to dismiss stage. To apply the same reasoning as the shock jocks example, I'd have to know more about what the ordinary listener of a rap diss track would think. And who is that ordinary listener? Is it someone who doesn't normally listen to rap and just happens to hear the song on the radio, or someone deeply involved in the rap community who understands the background and the style? That's important because in rap battles, sometimes accusations are made that are actually true and later proven true. So maybe listeners do think some lines are factual. Can I really say, as a matter of law at this stage, that they wouldn't consider this factual? Don't I need more evidence, maybe expert testimony or more specific context about this rap battle or rap battles in general before I can make that call? Well, here you go, Judge. This is the expert in rap battles.
I study rap battles for a living.
UMG's lawyers continue. In none of the cases do courts say you need expert testimony to answer this. The legal standard from both New York state courts and federal courts is that the judge looks at the materials presented and makes the determination based on the statements themselves and their surrounding context. For example, in the case of Touraine versus Liu, the court ended the lawsuit on the motion to dismiss. Just like here, it considered the context without needing experts. The same goes for the case of Rappaport. Now, that one was decided at the summary judgment stage, which is later in the case, but it still shows what kind of information the court looks at. That is, the actual language and the broader context in which it was said. That's it. Then the court makes the judgment. So the judge says, but if the broader context, which is what we're talking about here, is part of a specialized world, then maybe I don't have enough information right now. AKA, I don't know enough about rap battles and how fans or listeners of diss songs perceive them as either fact or opinion to really make the decision if this case is bogus and it's not defamation, or if Drake could make the case that the statements in the diss song are defamatory. So they continue, even with your request for judicial notice, do I really have enough facts to decide what a reasonable listener would think about whether these lyrics are fact or opinion? UMG's lawyer replies, Your Honor, the cases say you look at the materials available, including the context in the complaint itself. The complaint is the lawsuit. So basically, the typical process is you look at the overall context in which the lawsuit is being filed. Like if it's defamation because I wrote up an article saying some things about you and you thought they were defamatory, that's a way different context than one rapper saying some things about another rapper in a diss song. It's all about the context and the setting in which these statements were made in. And so they continue. In here, the complaint, the lawsuit, actually gives you plenty of context. It talks about the rap battle itself, articles describing the battle, articles describing the history between Drake and Kendrick, the rumors, gossip, and controversies about Drake and underage women that have been circulating for years. So the context is already in front of you. The law doesn't require you to think about one specific listener of Not Like Us who knows exactly this much or that much about the song. Because again, we're talking about a song that has now reached billions of people, right? So hip-hop fans might perceive the lyrics in Not Like Us a lot differently than a casual listener just hearing the song on the radio or on the Super Bowl stage. They continue. That would turn an objective standard into a subjective one based on individual knowledge. None of the cases do that. UMG is basically saying here, like, you can't just rely on a particular listener in any sort of setting to determine if this is defamatory or not. You can't rely on the guy who hears the song on the Super Bowl stage or the crazy hip-hop fan who knows everything about how lyrics in diss battles usually go, if they're usually fact or opinion. You got to take the overall broad context. So UMG emphasizes that, saying, the courts usually assume the listener has generally available information, and then they ask, what would that reasonable listener understand? In the Touraine case, for example, the person suing for defamation argued that the judge couldn't consider the overall broad context, aka the earlier statements that the person suing had made, because they weren't in his lawsuit. But the courts rejected that. They said you must consider the overall context of the issue, even if some of it comes from the plaintiff, aka the person who is suing for defamation. You must also consider their own prior words. And in that Touraine case, Touraine himself had described being in a war of words with another DJ who he was now suing for defamation. Because he put that in the complaint, the courts could consider it. And we have the same thing here. Drake's complaint, his lawsuit, talks about the rap beef, and it names multiple tracks from the beef and cites lots of articles about the beef as a whole. It even includes Drake's own line from his tailor-made freestyle, talk about him liking young girls, that's a gift from me. So when Kendrick raps in Not Like Us, hey Drake, I hear you like I'm young, there's nothing mysterious about where that came from. The lawsuit itself, plus the articles that Drake cites, gives you the context you need to decide this now.
I study rap battles for a living.
UMG's lawyer continues. Now, Drake's main counter-argument is that online comments that were made after Not Like Us came out show people took the lyrics as factual. But that's wrong for several reasons. One, the standard is objective. We don't look at what a handful of people thought. Even if 10 or 20 or 60 people post what they believe, that's irrelevant. Number two, the content of those social media posts that Drake cites, they don't help Drake in any way. Many of them are clearly joking. They use emojis, they have typos, profanity, racist language, or anti-Semitic slurs. That's not the quote-unquote reasonable listener standard. Number three, Courts have already rejected this type of argument. In the Rappaport defamation case, after Barstool Sports released a diss track about Rappaport brought in lots of online comments saying that people believed what was in the Barstool Sports diss track. The court threw that argument out, and the appeals court agreed. And finally, number 4, Drake himself has publicly warned against taking rap lyrics as literal truth, saying it harms the art form and chills artists from expressing themselves. We've submitted that as Exhibit A in our request for judicial notice. He was right then, and he's wrong now.
I study rap battles for a living.
They continue. Drake also says this is a quote-unquote mixed opinion, meaning Kendrick must have secret private facts about Drake's S-life. But again, Drake himself provoked Kendrick by saying, "Talk about him liking young girls, that's a gift from me." Kendrick then replied, "Hey, I hear you like him young," and kept going in Not Like Us. There's no suggestion of hidden facts. It's just a back and forth in a battle track, and deciding whether that's mixed opinion is still a legal question for the court. The judge says, but some lyrics, as Drake lawyers point out, hint that Kendrick does know more. For example, references to rabbit holes and other truths could be read as suggesting he has unreleased information. That's ambiguous, but at this stage, I have to read ambiguity in Drake's favor. UMG lawyer replies, the law says the court should still consider the full context in deciding that. In one case, for example, the court said that even when a statement might be based on undisclosed facts, like rabbit hole is still deep, I can go further, things like a hostile tone or anonymous posting can still make it clear it's just opinion. AKA, even if you're saying like, oh, you know, I have the facts on you, I know that you're this type of person or that type of person, if you're saying it in an angry tone, the reasonable listener can still be perceiving this as just your own opinion, right? And in another case, there was also a suggestion of unknown facts, but the court looked at the whole context, a heated public exchange, and concluded that it was still opinion. So like if me and you get in a fight and I'm like, I know that Drake took your mom out on a date. It's like if the overall context is that me and you are in a fight and we're exchanging insults, it's not perceived as fact. It's perceived as opinion. It's the same thing here, right? With Not Like Us, it was one of the last diss tracks in this battle where they're both saying horrible things about each other. So it shouldn't be taken as a fact because the whole context of the situation that Drake agreed to participate in was that these were just diss tracks being thrown back and forth to try and get as many insults off as possible. So here, when Kendrick says rabbit hole, it's part of the overall exaggerated style of Not Like Us. It's the same as when Drake raps that he'll reveal Kendrick's darkest secrets coming to light, or that he dug up bones in an excavation. That's all battle rhetoric. It's the standard in rap beefs. So the judge says,
I study rap battles for a living.
Nah, the judge didn't say that. They said, let's talk about one specific lyric, Certified Lover Boy, Certified PDFs. That word certified is ambiguous, but paired with PDF, it could make a listener think there's been some sort of official determination. What do you say to that? UMG's lawyer said 2 things. 1, you have read it alongside what comes before it. Certified Lover Boy, Certified PDFs. Certified Lover Boy is the name of Drake's album. This is a wordplay, swapping Lover Boy for PDF. And number 2, just like Certified Lover Boy doesn't mean there's an official certificate, Certified PDF here is part of that exaggerated insult. Like there's no such thing as an official Lover Boy, same way there's no such thing as an official PDF. So the judge says, but we're back to my earlier question. Who is the ordinary listener? Is it someone who knows Drake's album title and catches the joke, or someone who doesn't follow either artist and might miss the reference? UMG lawyer says, courts don't break it down listener by listener. They look at the whole context, not whether every listener will get every reference. Also, there's a danger in isolating single phrases without the surrounding context. In a prior legal case, the New York Court of Appeals warned against pulling out one line and ignoring the big picture. And in a separate case, even though parts of the article could be read as factual, the whole thing overall was an opinion. So the claim itself of defamation was rejected. And it's the same thing here. You have to look at the track as a whole. The back and forth with, hey Drake, I hear you like him young, Drake's own provocation, and the existing rumors. The judge says, that leads me to my second question about judicial notice. The rumors and gossip aren't all in the complaint, except in some lyric exchanges. You've submitted articles you want me to take judicial notice of. I assume that's not to prove the rumors are true, but to show they existed. aka in UMG's argument as to why this case should be dismissed, they cited a bunch of articles showing that the rumors of Drake being a PDF existed long before Not Like Us. Therefore, these were just exaggerated insults based off of rumors that Kendrick was just throwing into his diss song. So the judge here is saying, you don't want me to actually take these articles to be fact of like, hey, judge, look, Drake really is a PDF, so Kendrick wasn't lying, therefore it's not defamation. You want me to take these articles and say, oh, these rumors existed before, so Kendrick is exaggerating them in this diss song, where the whole point of a diss song is to just exaggerate your claims and make your opponent look bad. So UMG's lawyer says, exactly, it's not to prove truth, but instead to show that the rumors were out there, giving context to the lyrics. News articles and song lyrics are well within what the court can take judicial notice of, especially here, because Drake's own complaint cites these same articles. We're not introducing random new material. These articles are already part of Drake's own lawsuit, so the court can, and I think must, consider them, not for whether the rumors are true, but for the fact that they existed when these diss songs came out. Since context is required under the law and the complaint itself gives that context, it's entirely proper for you to factor it in. The judge replies saying, you said earlier you also wanted to address the other claims in this case, not just defamation. I'll give you a few minutes to do that now. The other claims are, of course, when Drake was referencing how they did bad business by botting the song, allegedly, using fake streams to boost the numbers, doing payola to radio, all that stuff. So UMG's lawyer says, yeah, we've already explained our challenges in the written briefs, and there's many, specifically the Section 349 claim. What that is the New York law about deceptive business practices. Drake was citing that to say, UMG, who's headquartered in New York, was using deceptive bad business practices to promote the song and market it. They didn't do their job properly. They did it illegally, essentially. And, drop a like, because we're learning a lot about law here. Just running this channel alone, I feel like I could become a freaking lawyer. But anyways, so UMG is trying to challenge this Section 349 claim, the deceptive business practices claim, and number 2, the penal code claim. That's Drake's attempt to sue under criminal statute. So on the 349 claim, they make a couple points. Number 1, Drake's complaint uses an information and belief style of pleading. That basically means Drake was saying, because all of the claims he made about botting and Kendrick using fake streams, they all started by saying on information and belief, Kendrick used bots on Not Like Us. They didn't say, based on these factual sources, Kendrick used bots on Not Like Us. Information and belief basically means, I think this is true, but I don't have hard evidence yet. And that's why this whole thing is going on. Because Drake's legal team wants this lawsuit to proceed to the discovery stage. That's when they collect all the information they want from UMG, the info on Kendrick's kids, Kendrick's record contracts, the information of Dave Free, Screwface John. And in this court hearing that we're reviewing here, this is at the motion to dismiss stage. This is where UMG is trying to make their claim that we should just dismiss this case right here, right now, instead of taking it further to the point where Drake has to peel through all our files. And UMG is basically saying here, because in Drake's lawsuit, when he accuses us of bad business practices with the bots and the fake streams, he doesn't use sources. He says on information and belief, aka I don't have hard evidence yet, but I think it's true. UMG thinks that's improper under the law. It's improper to accuse people of this on information and belief, and that alone is enough to dismiss the case. But the bigger issue is injury. Under New York's highest court, to have standing under Section 349, aka like to have merit under it, you need a direct injury, not an indirect or derivative one. Drake's theory here requires too many steps between the supposed consumer deception, which would be inflating the streams of Kendrick's song, and the harm that caused Drake. There's too many things in between, because Drake's claim was because more people were listening to it on radio, and they were only listening to it because UMG used payola, which is an illegal way to get the song played on radio, or because more people were exposed to it on Spotify because UMG was using illegal practices of putting it on fake playlists or smashing it all over the homepage or using bots to get it to climb the charts. Drake's argument is that because they used all these shady tactics to boost the song up on all these big platforms, that took away from his opportunity to get more placements on Spotify playlists, or his opportunity to get more placements on radio because they were playing Not Like Us so much. But you see how hard it would be to try to prove something like that, right? Like, how do they even relate to each other? The more plays that Kendrick gets directly means that Drake gets less plays. It doesn't necessarily make sense. So UMG is stating that there's too many steps in between us using bots and Drake's streams getting affected to actually say that this is a direct injury to Drake. Drake's big theory here requires too many steps in between. And the New York Court of Appeals rejected that in other different defamation cases. They both said, if the chain of events is too long and indirect, then the claim fails. Now, on the penal code claim, that's Drake's attempt to sue under criminal statute, our first and easiest argument is that there's simply no private right of action, meaning private citizens can't sue under this criminal law. So the judge says, thank you, UMG's lawyer. You'll get a chance to respond again at the end. For now, I want to hear from Drake's side. And then Drake's lawyer comes up to bat.
I study rap battles for a living.
And Drake's lawyer says, if I may, I'd like to start with the standard of review because it applies to all of UMG's arguments. It's important to remind ourselves what the federal and state rules say about motions to dismiss like this. Under binding Second Circuit law, a complaint can only be dismissed under Rule 12b-6 if it's beyond doubt that the plaintiff, aka Drake, can't prove any set of facts that would entitle him to win. And when we're at this early of a stage in the lawsuit, the complaint must be read liberally and in Drake's favor. AKA, unless at this early in the stage of the lawsuit, Drake has literally not one shred of sort of persuasion or evidence or anything to make this a reasonable case. Unless he has nothing, then we're going to rule in Drake's favor. That's how the courts have usually gone in these type of defamation cases, and we're allowed to proceed. Then they cite the same case, the prior case that we talked about earlier, because again, all this is based off precedent. What have defamation cases looked like in the past, and how can we apply that to this defamation case to make the law as consistent as possible? So in the Davis case, they say that's devastating for UMG's position when we're so early like this in the motion to dismiss stage. And here's what the Davis case says. 1. The question isn't what the judge thinks a reasonable listener should conclude. The question is whether a reasonable listener could conclude the statement was conveying facts about the plaintiff, aka Drake. That quote-unquote could standard means that if the statement can reasonably be read as fact or opinion, then the case goes forward. AKA, if the lyrics are too ambiguous to be able to completely rightfully discern, okay, this is a fact or this is an opinion, then it rules in Drake's favor because it could be both fact or opinion. And that is bad for UMG's case because this is going to be a case of really digging deep into the legal depths of like, how could a reasonable listener perceive this song? It's not black and white, like I said before. On this stage, we're only looking if Drake's claim is legally sufficient. The motion to dismiss must be denied if the words that are said that are claimed to be defamation, if those words in their ordinary meaning and context could also be taken as defamatory. So, if something could be read as fact or opinion, then the plaintiff wins in this stage, aka Drake wins and the case moves forward because the statements, the lyrics in Not Like Us could be taken as both fact or opinion, and it's going to be up to the judge to eventually decide which one it is. And the judge says, but I asked UMG's lawyer earlier, how do I look at that Davis case when I also have the other cases like the Bryan case, which was also a motion to dismiss case? Bryan didn't use the could standard, aka these words could be used as either opinion or fact. The Bryan case instead framed the issue as whether a listener would take it as fact or opinion and treated it purely as legal action. So in that Bryan case, it wasn't necessarily like, oh, here's the words, could they possibly be taken as fact? It was, when you hear these words right off the rip, would you take them as opinion or fact? There's a lot of little legal jargon here, but it gets a lot more entertaining very shortly, I promise you. And basically, Drake's lawyer points to the fact that UMG wants the judge to kind of look at the broader context of everything, right? The fact that it was a rap battle, the fact that the PDF rumors existed long before, and take that into consideration when looking at the lyrics in Not Like Us and whether or not they could be considered fact or opinion. And so the judge does that. The judge says, let's take the rap battle lyrics. Most of them are already referenced in the lawsuit. except maybe tailor-made freestyle, which you didn't include in the lawsuit. Drake's lawyer says, "We don't dispute that you can notice that the lyrics exist, but how you interpret them and what a reasonable listener would take from them is exactly what's in dispute. That's not something you can decide against us at this early stage." The judge says, "Once the lyrics are in, I can draw inferences from them. They're words. They mean what they mean. I don't see why I could notice them but not consider their meaning." And Drake's lawyer says, "Because at this stage in the lawsuit, you must draw all reasonable inferences in our favor. You can't use outside material to undercut our allegations. For example, our lawsuit says the context includes Not Like Us's lyrics, the cover art, and the music video. We explain in detail why those would lead a reasonable listener to believe the song conveyed a very specific false fact, that Drake is a PDF." So what Drake's lawyer here is saying that, like we mentioned before, right, at this early of the stage in the lawsuit, it doesn't matter the outside context, really. All that matters is it weighs heavily in Drake's favor to be pushed forward and continue, and then they'll get into the outside context. But for now, unless Drake has like zero argument to make on why Not Like Us could be defamatory, if there's a little bit of proof, the little inkling of an argument he can make, then the case will move forward. And that's why it did move forward. Drake's lawyer emphasizes the question isn't would they, aka would the reasonable listener, assume from the lyrics of Not Like Us that Drake is a PDF. The argument is that could they assume Drake is a PDF by these lyrics? And if the answer is yes, then we survive to the next step of this lawsuit. Again, at these early stages, everything is weighing very heavily in the plaintiff, aka the person suing, in their favor, because obviously you have to give them a fair shot if they're the one making the accusation. He continues, "Also, we've alleged that UMG engaged in a coordinated, covert scheme to make Not Like Us culturally unavoidable, to the point it became like a national anthem. This means the audience to consider isn't just hardcore rap fans following the beef, it's everyone who hears the song." And that's what makes this case so tricky, right? This is me talking, not Drake's lawyer. It's the fact that not only are they trying to argue whether or not these lyrics could be fact or could be opinion, it's that they're also trying to argue what is the reasonable listener? Who is the person deciding if they could be fact or opinion? Is it someone like me or you who follows rap beefs, or is it just the everyday listener because the song became a global phenomenon? There's billions of people who heard it, not just rap fans. And that's not even getting into the aspect of the lawsuit that makes the claim UMG used, illegal promotional tactics to blow the song up, right? There's so many layers to this lawsuit. It's going to take forever for this thing to get solved, and the fact that there's disgusting things like communication about Kendrick and Dave Free and his kids that are being dragged into this, it's going to be very, very messy. But back to the whole, who is the reasonable listener? They say that you use the audience that actually received the message, aka you use the whole audience of people who actually heard the song. They continue, "We've alleged that Not Like Us had more than 9 billion streams since our last filing, an unprecedented number. Most other rap battle tracks didn't come close. The relevant quote-unquote reasonable listener could be, say, a 13-year-old at a bar mitzvah hearing the song for the first time, not someone who's heard every diss track in the beef." And the judge says that would be quite a bar mitzvah song choice. Drake's lawyer says apparently it's very popular at bar mitzvahs.
I study rap battles for a living.
Drake's lawyer continues, "We've also alleged that in today's social media world, allegations of PDF land differently. They're more believable and cause immediate outrage. UMG wants you to ignore that based on their spin of their exhibits, but at this stage, you can't. AKA, because UMG came forward with a bunch of articles showing that there was rumors of Drake being a PDF long before Not Like Us, Drake's lawyer is saying, you can't ignore the fact that on social media today, if people get PDF rumors attached to them, they get barraged, I don't know the right word, attacked online, basically. And you can't ignore that, even though UMG is just pointing to a couple articles. You have to take in the full context of the fact that in today's social media landscape, these allegations hit much harder, especially on a massive song like this. And the judge says, but what about the tailor-made freestyle lyric? Talk about him liking young girls, that's a gift from me. In context, with the Tupac AI voice, it seems like Drake is daring Kendrick to bring up those rumors in the battle. Isn't that the only logical reading? And I love that, baby. Let that judge smoke Drake's lawyers. And this is going to come up a lot throughout this legal battle, right? All these rumors of Drake and everything. Like I said, this is going to get messy. Drake's lawyer says, Your Honor, In opinion doctrine, you don't isolate one line. You look at the whole song and broader context. The judge says, but I'm asking about that one line. How else would I read it? Drake's lawyer says, I don't think it matters for our case unless you assume that the average listener to Not Like Us also heard that tailor-made song earlier and interpreted it the way you just did. You can't assume stuff like that this early on in the case. The judge says, I understand most of these cases involve one standalone statement, but here, the songs are a back and forth dialogue. You can't ignore that Not Like Us was a response diss track. Taking it in isolation is like pulling one paragraph from an article without the rest. And great point, right? Even though the judge doesn't study rap battles for a living.
I study rap battles for a living.
The judge can still see that you gotta take the full context of the rap battle to understand if this is truly defamation. So Drake's lawyer says, we agree that context matters, but this song's impact and audience were different from the others. They were far broader, far bigger. That's why it's not the same as a niche back and forth rap battle that only fans followed. Basically saying like Not Like Us blew up way bigger than the rap battle. There's a different audience listening to that and interpreting Drake being a PDF. It's not about the rap battle anymore. And the judge says, but at the moment that Kendrick released the song, it was just another diss track in a days-long exchange. He couldn't have predicted billions of streams or a Super Bowl performance. The context I need to assess is the one at the time of the song's release, not months later after it went viral. Think of it like two people trading insults on the street. You judge the meaning of the insults in the moment, not based on how many people later saw a clip of the argument online. Isn't that the right comparison? Drake's lawyer argues that by saying, Your Honor, the role of republication in this case hasn't fully been addressed, and maybe we weren't as clear in our briefs as we should have been. UMG was responsible for republishing the defamatory material. What does republishing or republication mean legally? Under New York law, a defamatory statement is quote-unquote republished whenever it's intentionally pushed to a new audience and actually reaches that audience. In our case, we say UMG did this multiple times after May when Not Like Us was released, each time introducing the material to a fresh set of people. And every time that happened, UMG's knowledge at that point matters for liability. We know UMG was aware of the song reaching new audiences because we sent retraction demand letters in July and August of 2024, basically to retract the song. When it launched at the Grammys campaign, we also sent a retraction letter, and when it launched at the Super Bowl campaign as well. Even if you disagree with us about republication, we've also pled that the defamatory material includes not just the song, but also the cover art, which was also released in May, but then the video released 2 months later in July. When the video came out in July, UMG already knew Drake's home in Toronto had been attacked 3 separate times. His OVO business in London had been attacked. People across the US were calling him a PDF, and Drake had already publicly denied the allegations made in the Hard Part 6. So, at minimum, July is the point where their knowledge is clearly relevant, even before we start talking about republication liability. I don't want to stop this too much to give my opinion, but isn't this so ridiculous? Like, they're suing over the music video where he's bashing an owl piñata. It's not just the song. They're saying the freaking music video is defamation. They continue. Now, Judge, to your earlier question about whether the song can be separated from the context of the rap battle, we've alleged that this song became a standalone cultural phenomenon. And even UMG's own exhibits prove that. Exhibits are just like articles that UMG cites to basically defend their case. So in one example, which was a podcast transcript that they also cite in Drake's lawsuit, in the podcast, they have discussion like Drake is making allegations about Drake. Some of these things have been fact checks. A commentator says, I don't know if there's ever been a time when two superstar rappers, both making their labels billions, and one is accusing the other of PDF in the loudest way possible. Maybe it should inspire some sort of investigation. And later in the podcast, the transcript says, it's unclear if the claims of Kendrick's domestic abuse are true, but let's talk more about these allegations around Drake. No one's ever called him out like this. Now it's becoming a mainstream conversation because Drake's song is a hit. So basically, they're using this podcast to say that the narrative is now like, oh, you know, it's crazy Kendrick was making these allegations. And they're doing this to prove to the judge that the reasonable listener would perceive Not Like Us as making allegations about Drake being a PDF, right? And the judge rebuttals by saying, but didn't Drake also make accusations against Kendrick in this battle? For example, saying Kendrick's not the biological father of his child, or that he assaults his girlfriend? Are those lyrics facts or opinion? Drake's lawyer says, we don't have enough in the record to decide that now. Unlike here with Not Like Us, there's no complaint with 250 factual allegations giving meaning to Kendrick's lyrics. AKA, there's no lawsuit from Kendrick's side or UMG side about the allegations Drake made in Family Matters. There's no, cover art to prove that he was defaming Drake. There's no social media post talking about Kendrick being an abuser. But meanwhile, we have, this whole lawsuit concocted already about the allegations that Kendrick made in Not Like Us. Meanwhile, we don't know how people understood the allegations Drake made in Family Matters. So we don't know if that could be perceived as defamation. And I guess that's why they're requesting all these crazy things like, UMG's ties to Dave Free and Kendrick's kids and all the allegations of Kendrick abusing people and etc. Because they say that's something that UMG can explore in the discovery phase of this lawsuit when they start digging through Drake's files. But that's not a reason to throw out our case this early in the game. So yeah, that's why Drake's team now is asking for, all the info on Kendrick's kids and his assault history and etc., all the allegations against him, because they need to be prepared the next time the judge says, didn't Drake also make accusations against Kendrick in the battle? Wasn't this all for the sake of the battle? And now we get into the whole deceptive business practices claim, right? The whole thing about UMG using bots to artificially boost the numbers. So, remember, UMG said that Drake's lawsuit is all about on information and belief. There's no actual sources. It's all just, we believe this, but we don't have enough evidence yet to prove it. Drake's lawyers are saying, we've made 4 key allegations supporting the fact that UMG caused consumer harm. Number 1, bot streaming. UMG paid or caused payments to third parties to use bots to artificially boost Spotify streams. We allege that fake streams are a huge part of an industry problem. Up to 10% of all streams on all records are botted. Not Like Us broke streaming records. It was the fastest song to hit 300 million Spotify streams in 35 days. So they're pointing to the fact that Not Like Us broke all these streaming records to say, look, because botting is an industry problem and because Not Like Us broke all these streaming records, we have reason to believe that it was botted. They continue. Us, aka Drake's team, cites a podcast host saying that bots were used on Not Like Us. That would be Poetic Flocko. This is based on no real facts, right? Another one, alleged music industry whistleblowers saying that they saw bot promotion bot, and a self-described retired stream farmer showing how bots boosted Not Like Us. Under the law, pleading on information and belief is fine when the evidence is in the defendant's possession, especially for covert schemes, aka if only UMG knows if the song was actually botted, then it's fine for us in our lawsuit to say we have information and belief that it was botted, because how are we supposed to know? We have to dig through UMG's files to be able to prove it. There's no other way. So we have to use the argument of this is all information and belief. And they continue. UMG gave streaming platforms financial incentives like reduced license rates to push Not Like Us in playlists and search results. This is, by the way, something that's available for any artist. You can take a reduced rate, reduced profits, and Spotify will boost your song more. They continue. Pay for play, payola. UMG paid for extra radio and streaming placements. And then also misleading success claims. UMG bragged about the song's success while knowing that the numbers were inflated. The manipulated search results of Not Like Us directly diverted listeners from Drake's music to Kendrick's. That's direct financial harm. Fewer streams means lower royalties, aka because more people were directed to listen to Not Like Us, then less people can now stream Drake's music, and that affects his profits. So the judge asks, but how are bots or pay for play connected to redirecting people who search for Drake's music? Drake's lawyer says, the bots are a separate harm. Bot streams dilute royalty rates for all artists that are not using them. So yes, theoretically, every artist could sue over that, and that's allowed under Section 349 in the Business Code. Any person aggrieved by consumer deception has standing. Here, consumers searching for Drake were deceived into streaming Not Like Us, causing him both direct loss, less traffic to his music, and dilution loss, lower royalty rates. I'd be very interested to see if they actually factually prove that when you search Drake's name, Not Like Us would pop up. I never saw that issue. Drop a comment if you did. And now it's time for UMG's lawyer to come and rebuttal the claims. They emphasize again, we gotta look at a bunch of things, not just Not Like Us. For example, the fact check comment isn't about Drake being a PDF, it's about a different rapper, Baka Not Nice, Drake's artist, convicted of assault and accused of running a prostitution ring. They also talk about stories like Drake going to girls' basketball games and about Millie Bobby Brown's friendship with Drake when she was 13 and he was in his 30s. That's crazy. That's context. And same goes for lyrics like Drake's own tailor-made freestyle line. Talk about him liking young girls, that's a gift for me. Here's the full surrounding lyric. Kendrick, we need you. Call him a B for me. Talk about him liking young girls, that's a gift for me. That's battle trash talk, rhetorical hyperbole, not a factual statement. And on the business practices side of things, Drake's injury is still indirect, aka like the whole thing with Not Like Us being a success, that causing injury to Drake because now less people have the opportunity or time to stream him. That's indirect because it requires multiple steps through consumers, Spotify, and royalty mechanics to actually prove it. The law requires injury to be tangible, non-speculative, and direct. Otherwise, the courts would be flooded. And this is where this part of the saga ends, and the judge ends up writing a letter to say that the case will move forward with the discovery phase. The discovery phase is now when Drake and UMG's teams can say, hey, UMG, we, Drake's team, want all these documents from you guys. That's when they requested Kendrick's contracts, all the Interscope record, bonus incentives, the information about Kendrick's kids, disgusting stuff. They wanted a bunch of stuff from UMG, and then UMG can also be like, hey, Drake's team, we want all this information from you guys to be able to build our cases. And now we have another interesting development because as I was making this video, obviously we know that Drake's team wrote a letter to the judge saying, hey, judge, we request all this information from UMG. Again, Kendrick's contracts, the kid information, Dave Free information, the abuse allegations, anything you guys have on all this stuff, we want that information. UMG has now responded to that. They sent a couple letters to the judge, so we'll summarize them all. In the first one, UMG pushes back against Drake's latest attempt to force them to hand over certain documents, and they say that the requests that Drake is asking for are overly broad, irrelevant to the lawsuit, and clearly aimed at harassing people that Drake sees as rivals, especially Kendrick Lamar, Interscope Records, which distributes Kendrick's music, Interscope's CEO John Janik, and UMG as a whole. They point out that Drake is demanding things like John Janik's personal pay and bonus records going back to 2021, which is 4 years before Not Like Us was even released, and Interscope's 2024 executive bonus metrics, even though the case is about one song and music video from 2024. And even with that, Drake hasn't shown why John Janik would have been motivated to promote Kendrick over any other artist. They also call Drake's theory that UMG's structure had somehow pitted Kendrick Lamar's Interscope label against Drake's Republic label, which are both labels under UMG. That's pure speculation not found in his own lawsuit, and they argue that there's nothing unusual about executives being paid partially on their own record label division's performance. Like, there's nothing crazy about John Janik, the CEO of Interscope, being paid based off how Interscope specifically performs, not about how UMG as a whole performs. They reject the idea of giving 5 years of sensitive compensation data or broader bonus structures for other executives because they call that basically fishing expeditions. Like, Drake is just fishing for very internal private data that any artist should not be able to see. UMG also attacks a bunch of other requests where Drake wants all documents since 2020 about any UMG censorship or alteration of any song or video across its 220 plus artists and 3.2 million recordings and any similar actions involving Pusha T's diss track, The Story of Adin, because Drake was also requesting any sort of communication or documents UMG had pertaining to the release or the censorship or blocking of that song, because they did censor Pusha T as well. UMG says this is absurdly overboard and irrelevant except for asking for Kendrick's contract, which they already partially produced, and that personal opinions or past actions by UMG don't affect the legal reasonable listener standard for defamation, aka all these documents that Drake is requesting have nothing to do with what a reasonable listener would perceive about Not Like Us. This is going far beyond his one case in the lawsuit. Then you have other requests where Drake wants 5.5 years of Interscope's monthly revenues and profits and the historical value of Kendrick's catalog. UMG calls these irrelevant and unworkable, noting that you can't isolate Not Like Us's impact from other events and that past catalog valuations have nothing to do with whether UMG tried to get Kendrick to re-sign his contract. Because Drake is trying to, create this grand conspiracy, essentially, that UMG used Not Like Us as a motivation to get Kendrick Lamar to re-sign with them. And finally, on Kendrick's recording contract, UMG explains they already gave Drake all the sections that show their right to approve, reject, or edit Kendrick's work, plus the section headings, but blacked out irrelevant or highly sensitive business terms. They argue that courts do allow such redactions, especially with commercially sensitive info in competitive industries, to basically eliminate the risk of harm. And if the judge is unsure, they propose that the judge reviews the full contract privately. And overall, UMG urges the court to deny all these requests as irrelevant, disproportionate, intrusive, and in some cases designed to embarrass or annoy, keeping redactions in place unless the judge herself sees a reason otherwise. In their next letter to the judge, UMG says that Drake's request to make Lucien Grange, the CEO of UMG, a document custodian should be rejected. They remind the court that Drake has already agreed not to go after Lucien Grange's files when UMG agreed to provide the documents from 11 other people, including the CEO of Interscope Records and Kendrick Lamar. And of course, the CEO is the one who actually oversaw the release of Not Like Us. It wasn't Lucien Grange. UMG calls Drake's request a bad faith move meant to bother the company and waste time, saying Drake's theory that losing a rap battle must mean there was a secret plot all the way at the top of UMG is ridiculous. They explain that Lucien Grange runs a massive global corporation, and he does not get involved in checking individual songs, album covers, or marketing campaigns. And, in a sworn statement, he said he never even heard Not Like Us or saw its cover art or video until after Interscope released them. UMG cites legal rules saying the responding party normally gets to pick the people whose files will be searched, unless that choice is clearly unreasonable. And the other side must prove that adding someone else to, who they want to search will give new relevant information that isn't just repeating what's already been found. They say that Drake hasn't met this standard, since his claims about Lucien Grange's involvement are based on, again, information and belief without facts. And Drake's team even includes petty points like Lucien Grange celebrating Kendrick's Grammy win. UMG also says Drake's argument about actual malice, claiming that Lucien Grange's files could prove that, doesn't work because in defamation law, the plaintiff, aka Drake, must show the specific person who published the statement acted with malice, and there's no sign that Lucien Grange was that person. It was Kendrick. UMG points out that any relevant documents Lucien might have would already be in the files of the 11 people that Drake requested information from that UMG already handed over, and that Drake's claim that the duplication doesn't matter goes against long-standing discovery rules. They also note that Drake hasn't shown any evidence to justify adding Lucien Grange, and his fallback, which is that Lucien should be added just because Drake wants him, is not a valid reason. UMG ends by telling the judge that this is just an attempt to harass and it's not a real discovery need, and asks her to deny the motion. And then Lucien Grange wrote a letter to the judge himself, which I'll simplify for you guys and basically read out as if I'm Lucien Grange. All right, we're going to role play a little here because this letter is very interesting. So it goes. I'm Lucien Grange, the chairman and CEO of UMG, which is the company that owns UMG Recordings. Drake is accusing me of being behind some sort of plan to hurt his brand by releasing and promoting Kendrick's song Not Like Us. That accusation makes no sense because my company has invested hundreds of millions of dollars in Drake over the years. We've provided major financial support for his career. And this one's very interesting. We also bought and own most of his recording catalog and also bought his music publishing rights. Do you understand what that means? Like, now it's very clear why Drake is doing this, right? With UMG, why he's going to war with them. They own most of his publishing rights and catalog. They own most of Drake. That's what also might get crazy with this lawsuit is on both sides, like they're ripping through some very confidential financial stuff, contracts, etc. Like we're going to get a real peel behind the curtains to see what dynamic does Kendrick have within the industry in terms of how his deal is structured with UMG? How is Drake's deal structured with UMG? What incentive would Drake have to try and leave the label? How much of his catalog do they actually own? They're literally saying here they bought most of his recording catalog. That's in this letter to the judge from Lucien Grange, the CEO of UMG. So the whole thing on push-ups, pull your contracts because we got to see the splits. You ended up suing, and now you're exposed for the fact that UMG owns most of your freaking catalog. The thing that you've bragged so much about, that you're liking posts on Instagram of, oh, Drake's catalog surpasses Kendrick's on Spotify. Yeah, laugh all you want, buddy. Kendrick right now is independent. GNX, all those streams go directly to PG Lang. Right now, UMG bought and owned most of your freaking catalog. I'm going to read this in word for word what Lucien said. We've invested hundreds of millions of dollars in Drake, including long-standing and critical financial support for his recording career, the purchase and ownership of the bulk of his recording catalog, and the purchase of his music publishing rights. We own most of Drake. Why would we purposely try to defame him when we own most of his catalog? It also makes no sense because of the scale of my job. I'm back to being Lucy and Grange here. I run a publicly traded multi-billion-dollar multinational company that operates in over 60 countries and nearly 200 markets. We have over 100 record labels, plus a worldwide music publishing division, global merchandise, and direct-to-consumer businesses, the Global Virgin Music Label Services, both short and long-form video production, and many other businesses. Each label or division has its own CEO or president and its own management team. Together, these businesses put out tens of thousands of releases and products every month. My focus is on creating and carrying out UMG's global strategy for the long term. With that many releases happening worldwide, the idea that I personally get involved in the release and promotion of any single song is absurd. In my position, I'm used to being the target of personal attacks, and I know that some of UMG's opponents in lawsuits try to waste my time and the company's resources with demands for documents like the ones that Drake is asking for. This is often done to get media attention or to pressure us into making business deals or financial concessions. Still, because Drake has filed this motion, I want to be absolutely clear. I had never heard Not Like Us, nor seen its cover art or music video until after Interscope Records released them. While I do have overall financial oversight and responsibility for all of UMG's global operations, the idea that I was involved in or was responsible for reviewing or approving Not Like Us, its cover art or music video, or for deciding how they should be promoted is completely baseless and frankly ridiculous. I declare under penalty of perjury that everything above is true and correct. He's literally swearing under oath that he owns most of Drake's catalog, along with many other things like that he was not responsible or even heard Not Like Us before it was released, right? Do you see how freaking ridiculous this is? Alright guys, I don't know what else to tell you. I'm not even going to offer my opinion much in this video. We're already at an hour, 6 minutes. So if you stuck along for this entire ride, thank you guys very much. And let me know what you guys think, and I will catch you in the next one.
I study rap battles for a living.